Brussels Privacy Symposium. It's incredible that it's been 5 years of deep looks at some of the important issues in data protection, ethics, policy. It's been great at the Future of Privacy Forum. I'm Jules Polonetsky, CEO. Should have started with that. It's been great to partner with the Brussels Privacy Hub. Christopher Cooner, one of the scholars who taught me privacy 25 years ago when I first started, and now with Gian Claudio, really a phenomenal team, and we've really enjoyed and I think helped elevate some of the discussions, both in a initially transatlantic way, which was our goal, but today I think we're proud that we've all started appreciating that it's not just Europe and it's not just the US that should be filling all the spaces when it comes to discussions of emerging privacy and data protection issues. These are issues that every region in the world is debating, and it's phenomenal that we've got representatives from a number of key areas and real leaders who will be part of this discussion. In the 5 years that we've been doing this annual program, usually in person with delightful coffees and cocktails, but today virtual, we've taken on day-long programs on anonymization and de-identification, day-long programs on AI and ethics, data sharing for research, the intersection of data protection and competition, and then of course today, the actual regulating of AI, given that that's where we are today. So I think we've, with input from many of you, selected wisely, often spending 5, 6, 7 hours with people who really are ready to think hard and think deep. This has always been an interdisciplinary type event where we've had academics and civil society and government and companies, because the issues here really are the kind that require thinking from all corners of society to try to puzzle out the picture and the solution. Without further ado, let me turn to our partner in this effort, Christopher Cooner at VUB.
Well, thank you very much indeed, Jules. I'm Christopher Cooner. I'm a professor of law at the VUB Brussels and co-director, one of the 2 co-directors of the Brussels Privacy Hub, which is a research center associated with the law faculty of the VUB. I'd like to also welcome everyone here to our 5th annual Brussels Privacy Symposium. I'm going to be very brief, and I would mainly like to thank first of all of you for attending, and our fantastic speakers for making time to be on this program. And of course, also to thank Jules and all of his great team at the FPF. It's been always, over these years, just a pleasure to work with all of you. And indeed, it is remarkable, as Jules said, this is our 5th annual symposium. This seems to have become a real fixture. And we plan to continue it, and we seem to be just getting better and better as the data landscape, the regulatory landscape becomes more and more complicated. I'd like also to wish everyone health and hope that you're all doing well in this difficult time. And I hope you will find today interesting. I think you will, because the topic is certainly very interesting. And with that, I'd like to turn the floor over to my co-director of the Brussels Privacy Hub, who's also the moderator of our first panel today, Professor Gian Claudio Malgeri. Gian Claudio.
Thank you very much, Chris, for such a warm introduction. Thank you to our dear friends of the Future Privacy Forum, who, as always, did an incredible work for this wonderful yearly event. Thank you to Jules, Omer, Gabriela, Rob, Sebastiano. Thank you very much to Alessandra Calvi, our managing director. She's here with me, and all of the team that worked so hard to have this incredible conference here. So today is a day of inaugurations and celebrations. And despite the many concerns we still have in these days, this is the inauguration of a new age for our new entities, because we have the European headquarters of Future Privacy Forum today to inaugurate. Also, I'm honored that I'm here for the first time as co-director, and Gabriela, first time as VP for Privacy, so of Future Privacy Forum. So I take the chance to thank Paul Dart for the incredible and generous work that he conducted in this first 7 years of the hub, together with Chris Cooner, and for the trust they both had in me. The idea behind the foundation of the hub was brave, and I'm honored to join this journey with Christopher Cooner. So sorry for this personal thing, but Chris was a mentor and an inspiration for me. So the Brussels Privacy Symposium, its 4th edition, has been always addressing incredibly timely issues, even before that they became source of scholarly policy and jurisprudential discussion. Anonymization the first year, transparency in AI second year, data and competition law third year, and data governance and scientific research last year. Topics that, starting from Brussels, have affected the whole global discussion. The topic of this year was a bit self-imposed and a natural choice. Most of us have been working at automated decision-making, explainable AI in academia and policy venues for at least 6 or even 10 years. And now finally we have a new text to discuss, the AIA, the AII Act. There are many challenges in the EU strategies for AI. And we are excited to have such a high-level policy panel to discuss the next legislative steps, but also we will have 2 broader focuses in the following panels: the need to blacklist AI and reach a minimum consensus for unbearable AI, and the global perspective with distinguished and award-winner experts from all over the world. So I think it's time for bridging us to the keynote panel. I see that our first keynote is online. I am checking if we have the other keynote connected, because otherwise I can take just a couple of minutes waiting for the other keynote before introducing the 2 keynotes. Just explaining a bit the scope and approach and aim of this first panel, which is a keynote policy panel. You all know more or less about the AI Act, so the Artificial Intelligence Act. It's a long and brave proposal that the European Commission published a few months ago. It was April. I see that now both our keynote speakers are there, so I can avoid wasting any time and introducing them both. So we have the honor to host 2 amazing speakers, and even more honored because they are 2 fellow connationals of me. So I can't be more proud to see 2 Italians in key roles dealing with this high challenge. So apart from chauvinism, I will. So the first is we are very honored to have here Mr. Brando Benifei. He's the head of Italian delegation of the group of the Progressive Alliance of Socialists and Democrats in the European Parliament. He was confirmed in this role again just 5 days ago, so congrats. And he's also a member at the European Parliament since 2014. So he has followed the developments in these and other topics. Then he served in the Committee on Employment and Social Affairs, and in 2019 he moved to the Committee for the Internal Market and Consumer Protection. In 2020 he joined the Special Committee for Artificial Intelligence, and he serves as lead rapporteur on the Artificial Intelligence Act. So we are extremely happy to have him here. Thank you very much. Our other keynote speaker is Dr. Lucilla Scioli. She's the Director for Artificial Intelligence and the Digital Industry at DG Connect of the European Commission. She's responsible for the coordination of the European digitization of industry strategy and for policy development in the area of artificial intelligence. The Directorate also supports key digital industrial technologies, including robotics and AI. And she has served in the European Commission in the last years in key roles dealing with key challenges of AI, technology, and so on. So thank you very much to both our speakers. I would like to start from the strengths, the strong points of the proposals, and then we can discuss the eventual criticism. So I would start with Dr. Scioli, because the strengths are probably best invited by the Commission. So Dr. Scioli, the floor is yours. I think you are muted.
Thank you very much, and good afternoon to everyone. So you asked me about the strengths, and if I had to tell you the strengths of the proposal, I would be repeating the proposal again and again. In fact, it is, first, let me notice and highlight that this is the first comprehensive proposal for a regulatory framework on AI in the world. And I think this is a very important element for this proposal. So for a long time, many organizations have been presenting principles, including ourselves with our high-level expert group. But it's the first time that there is an organization which succeeds in operationalizing these principles and codifying them in rules. And I think this is a very first important point to note, because it's the probably standard to which other countries will also aspire to. What I consider to be a very important point is the fact that it is horizontal, in the sense that it applies to all the sectors. And this is important because it simplifies the approach also for the developers of artificial intelligence. They don't have to think how the application will be used to understand whether it will fall under a set of rules or another set of rules. So it's very important that it's a horizontal. At the end of the day, the problems of AI are the same, whether you apply them to employment or whether you apply them to something else. And the problems are about opacity and complexity and autonomy of the artificial intelligence system. So this is why we think one horizontal act is very important. It's important because it includes a mechanism which makes it future-proof. We are talking about a technology which is innovative. And so we have introduced a system through which we can update, for example, the definition of AI or the list of high-risk use cases through delegated acts, still in discussion with the co-legislators. And I think that another very strong point is the fact that what we have essentially proposed is a certification system similar to the CE marking, which is already in use in the European Union for many devices. And this has two advantages. The first one is that it uses organizations, surveillance authorities, and players that are already in the European market, are already active, conformity bodies, market surveillance authorities. For some sectors, they're already active. And so we are not increasing red tape. We're just trying really to use what already exists. And secondly, because by proposing this system, we are creating a level playing field for everybody, in the sense that developers coming from other parts of the world will have the same obligations as the European providers. And so we believe that we have created a level playing field. And let me say maybe a very last advantage is that we focus on a list of use cases applications, instead of asking, as it happens in other European legislation, to a company, make yourself a risk assessment of this application and decide if it's risky and falls under the rules. We tell from the very beginning, these are the use cases that are captured by the framework. If you develop an AI that falls under these use cases, please check its compliance and so on. And so we think that we have created legal certainty by doing that. Thank you.
Thank you very much, Dr. Scioli. I think the points on the table are many. So the horizontal application, a risk-based approach, use case application that helps to, avoid the risk of arbitrary self-risk assessment and so on. But even in these points, there might be some problems in interpretation, in application. For example, this blacklist that can be too limited for some people. And now we will discuss everything. But so I want to leave the floor to Mr. Benifei, asking what is the position of, your position as special rapporteur to the initial text of the Commission? What are the points on which you would like to work that you think can be improved and so on? Thank you.
Yes, first of all, thank you for inviting me. Sorry if I connect from this strange background, but I need to attend after another seminar outside the parliament. So I decided to move to the venue to do this discussion. So that's why you see a strange background. Thank you for inviting me. Thank you for this work on such an important act that we are starting to examine. In fact, the formal work of the parliament on the file has still to start, because we are in the process in these days exactly to conclude on what to do with the various committees in terms of the level of involvement on the various expertises that we have in the European Parliament. So in a short time, the real work will start, but as you can imagine, the informal discussion is already very heated. We had a lot of exchanges, a lot of discussions between colleagues and with stakeholders. And what I can tell you is that for sure, the proposal has a certain degree of ambition. We appreciate that from the Commission. It has taken from what we have written in our papers, in our INI reports. It has taken a lot of inspiration and of content also, and attention to the work of the Parliament, and we appreciate that. For example, one thing that the Parliament has stressed in the pre-legislative phase was to not have a too black and white division between AI that needs no regulation and AI that needs a lot of regulation. We appreciate that in the end there is a certain degree of nuances with, for example, not just the low-level, low-risk AI, but also an intermediate level that has the necessity for transparency. And then the high-risk users, there is a comprehensive list. We will want to look for sure at how we can refine the list. And also on the certification issue, we have some doubts that it can be just left in a way it is today to, I give you an example, to that we find out after years that there is an algorithm because of market surveillance authority intervention, there is an algorithm that like it happened in Netherlands in this, even in these weeks, there is again attention on this, that minors were subtracted from their families because of a erroneous algorithm, and this means also welfare benefits. I was yesterday in Barcelona in a conference on the urban impact of AI, and there was a scholar from the US explaining how systems of AI used in US are creating problems for people that are entitled to welfare benefits, that they are not getting them, even if they had the right to do it, and so to get it. And I think that this issue of this self-certification will need to be looked at very carefully, because there might be the need for some ex-ante verification when we look at issues that deal with fundamental rights. I think this will be an issue we will look at. We are not totally convinced by the approach. Then also, there is the issue of the biometric surveillance, on which the exceptions are, for many of us, considered to be too broadly interpretable by the judiciary and by the executive authorities. So we think we should see if we can be more precise, or either go for a clear ban. Also because there is a forbidden for social scoring, but if we don't do some things around these limits of the regulation, I think that the social scoring might happen, even if it's on paper it's forbidden. Social scoring in the sense of making a hierarchy of the citizens, if they are good or bad, like it happens in some authoritarian regimes. And lastly, one very contentious point I need to put on the table, it's the introduction of AI in the workplaces, where in the present proposal, we don't see any space for the social partners, and we don't see enough attention to a very, very delicate issue like this, where we see already abuses happening, and I think we need to be to have a more robust approach than the one that is today in the regulation. So just to show you that we know and we share the approach of having a regulation that is able to build an ecosystem of innovation of AI that also, for example, through the sandboxes, will let experimentation of startups that doesn't increase useless bureaucratic activity, but we are worried that we need to balance the market, the internal market building approach to the fundamental rights protection approach in a good way. So we will look at that and see how we can amend in the senses I just listed. Thank you.
Thank you very much. I think we already have the two positions on the table. Of course, it's not one against another. It's just starting a discussion. There will be the trialogue. Also, I forgot to mention that we were trying to have also the third part of the trialogue here. So in particular, the Council, the French Ministry of Digital Transition, Mr. Cédric O, but he couldn't be there. So it will be for next event. I think that in the points that Mr. Benifei raised, we already have many points of discussion. So let's start from the first one. We have another like 30 minutes. I would like to say that there might be some, I would like to have some Q&A at the end, so in the last 10 minutes. So now if we try to analyze together a bit the AI Act, also for the benefit of all our 240 members here, panel members on Zoom. So the first thing might be beyond the definition of AI. I will not dig into that definition. It's some people say it's broad, other people say it's vague. I don't think we have time to deal with that, but let's look at the high risk list. So the risk, we said it's a risk-based approach. And Dr. Scioli said it's a great point, like it's a good starting point, of course, because it simplifies also the self-assessment. But also taking the input from Mr. Benifei, what about, I mean, in the annex, no, sorry, in the blacklist, so the forbidden AI practices, is that list comprehensive enough? So, for example, social scoring was mentioned now, biometric surveillance, also the reference to vulnerability, for example, vulnerable people. This is a topic I care a lot. Vulnerable people are considered if they are exploited under a psychological, if they are exploited, or if there is a manipulation, regardless of vulnerability, that produces physical or psychological harm. These requirements might be seen as a bit too restrictive because, of course, there might be economic damages or might be other forms of vulnerabilities, or also for, just to taking the example of social scoring. Social scoring is not forbidden, it's forbidden under certain conditions. So asking to Dr. Scioli, do you think there are some margin to improve these things, or this was like the best compromise in the blacklist? There will be another panel about the blacklist later, but in the AI Act, what is your position about this Article 5, basically? I think you're muted.
Of course, I think it is comprehensive, sufficiently comprehensive. This is our proposal. And of course, we had to, when you write a legal act, you have to be very precise. And you also have to keep in mind the practical implementation of the rules. So in this case, for example, we had to specify that we were looking at age or disability in terms of vulnerabilities. We found other kinds of vulnerabilities be very difficult to check and then to control the implementation of this particular article, which is forbidding certain activities. So it's very important. There is no mistake to be made here. And the same goes for the for the economic activity. Let's not forget that this act is building on existing European legislation. So there is already, the concept of economic harms that has been addressed quite extensively by the Unfair Commercial Practice Directive. And therefore, we didn't think that there was a scope here to repeat what was already addressed as manipulation between business and consumer practices. So you have to keep in mind when you look at this act on AI that it builds on existing legislation, which is the Unfair Commercial Practice Directive or the General Data Protection Regulation or the Digital Service Act, which is under discussion. So these are all pieces of legislation that relate very closely to this act. So you need to look at the act in conjunction with the others as well, not in isolation.
And what is the position of the Parliament? Mr. Benifei, how do you think you could work on this Article 5 if you are planning to extend it or to change it? Because of course there is a problem of specification. We have to be precise, right? But being precise includes being narrow in some perspective. So what is your position on that?
Yes, well, on this specific point, first of all, I need to say that this for sure will be one of, or even the most complicated discussion inside the Parliament. So I cannot say what will be the outcome of the discussion. I can tell you that I see already one thing, which is not just an impression, but it was a position taken already officially by the Parliament, because the Parliament has approved a non-binding political resolution that, however, applies very directly on this work on the AI regulation. That is a resolution regarding the forbidding of the biometric surveillance through facial recognition in public spaces in real time. So this is something where it's clear that the Parliament has a majoritarian view that is more restrictive than the text that is now in the draft report. So I can imagine that this majority that expressed in the resolution will be mirrored when we will do the amending work for that. So on the biometric surveillance, we probably want to be more restrictive than how it is in the Commission text. And if I can say, the Council is not here, but I suspect that the Council will say that they want to be less restrictive. So it will not be easy to discuss. And then I want to stress again that even though social scoring is forbidden, if we are not very careful about all these dangerous issues regarding discriminatory algorithm, regarding the, again, the surveillance, in fact, we will allow social scoring, even if it's it will be allowed as a hidden social scoring. Like we have seen scandals happening in private companies, in the public sphere in these years of spying, of compiling lists of people, of violating data protection. It's true, as obviously the Commission just said with Dr. Scioli, that we have a lot of already existing legislation, but we need to be sure that we have a context where the legislation is enforceable for these objectives. So for sure, we will need to work more on the Article 5.
Yeah, so just getting your last point on biometric surveillance, maybe there is something close to facial recognition that has not been addressed so much, but the European Data Protection Board and the European Data Protection Supervisor in their joint opinion did, which is emotion recognition. It's between pseudoscience and real science, and it's also very problematic. Of course, it's something that we all don't want. We don't want to be recognized in our own emotions and so on. The parliament took this position against facial recognition, but on emotion recognition, we had mostly the EDPS and DDPB to take a position. The point is, I mean, what do you think? Because of course, in the current AI Act, just to the benefit of the audience, is considered limited risk. So emotion recognition taken alone, not applied to particular contexts, is considered to have a limited risk. So there are some transparency duties. Transparency duties means that we have to declare that this is an AI and that is doing emotion recognition, but it's not opt out, and also it's not put in the high risk list. So maybe this was because, of course, it's difficult to define, and also because, of course, emotion recognition in some contexts is high risk, for example, school, etc. But I want to hear from Dr. Scioli about this point. What I mean, if you can elaborate more on this.
Well, let me say, first of all, that emotional recognition is not always bad. There are a lot of usages of emotional recognition that are actually good in healthcare or in other contexts. I don't know, in cars, or, you know, there are many activities or applications, let's put it this way, of emotional recognition that are actually beneficial for us as people. Then there are those who diminish us. And so, or some individuals perceive to be diminished, other individuals don't really care, but many individuals will perceive to be diminished. So in this case, what we ask is that there are transparency obligations, so that the individual is informed that an emotional recognition system is being used under that particular application. This means, in a way, that people can decide not to participate to that activity. Then I think it is up, for example, if it is a shop that uses emotional recognition, some shops do, to see how people react when they look at their merchandise, then the shop would have to flag that they are not using it. And then people may go to another shop, and then the shop owner has to ask themselves whether they want to continue using it or not, or offer different ways to people to access the service that they actually offer. So the fact that we ask transparency about it means that we recognize that it can affect the people, and that people can perceive this as a negative intrusion into their life. But again, we don't want to ban it, because we don't want to be in a situation where a lot of positive applications will actually not be put on the market.
And so, Mr. Benifei, what do you think of this points on emotion recognition?
Well, I have to say that on this specific point, the Parliament still hasn't discussed very much. As I said, again, I'm talking about informal discussions, because the formal work still has to start. But I have to say that this is a less treated point. However, I can tell you personally how I see it. I have to say that maybe with a little less optimism for a good use, I generally share the approach that Dr. Scioli has explained, in the sense that I see a certain degree of opportunity for bad users that I'm not sure that it will be always easy to counteract, also with using both the Act and the existing legislation. But I'm not in favor of a extremely restrictive approach. So I think we will need to see with the discussion in the parliament if the present limitations, the present rules on transparency that we have in the Act are sufficient or not. I think it would be important to look at what use exactly is foreseen for the emotional recognition, which is also, as it was said, to some extent a field where we see some action, some activity that has some sense, and in other parts it seems to me also, by reading about it, of pseudoscience. So it needs to be treated very carefully, especially when the public authority is involved.
Yeah, sure. I mean, this discussion on emotion is long. Even data protection scholars notice that emotion are not exactly protectable very well under the GDPR, because the sensitive data definition is not explicitly mentioning emotion. So it's a long topic for discussion. Of course, if the regulation is going to be applied for the next 20, 30 years, we have to take into account also this futuristic cyberpunk options. But now let's talk just, and then we go to the Q&A, to the safeguards that are in place. So because it's also a strength or a point of discussion. We mentioned the risk, but for high risk, there are some safeguards in place. And I think this is the first time we have a regulation that requires, for example, human oversight in such a complex way, right? Human oversight, then we have risk management and data governance, where the AI user and developer have to map the gaps and also contextualize it. But there are not individual rights. So a criticism that was made is that the approach is very much a safety approach, like regulating the market and not regulating individual and fundamental rights. And so, for example, it was under the competence of DG Connect and not of DG Justice. So, so going to Dr. Scioli, about this point on individual rights and safeguards, maybe there's already in the EU legislation, but how do you reply to this various criticism about this point?
Well, first of all, I would say that we did not aim at introducing new rights. We aimed at making sure that fundamental rights are respected. So we aimed at introducing a mechanism that minimizes the possibility of distortions of fundamental rights. And this mechanism consists in an ex-ante conformity assessment by then putting the product of the service on the market, and then in case of harm, having market surveillance authorities, and not only market surveillance authorities checking what went wrong, but we also give the possibility to many other organizations and courts as well to have access to the information in case something goes wrong. So it's really not only limited, this power is not only limited to the market surveillance authorities. I think this is very important to keep in mind. I also think that this mechanism works well. The point of departure is also the fact that artificial intelligence is often embedded in products which may already be subject to this kind of conformity assessment. And so for when it is the case, for example, in a robot, it means that the robot undertakes a conformity assessment, and it will have to add a new stage, which is actually looking at the artificial intelligence that enables that robot or machine. Then the novelty is the conformity assessment applied to AI as a standalone, almost as a software, as a service, simply. And that's where we require, we request actually self-assessment. This is what the Parliament, as we heard, does not like very much. And it's the first time, it's new. And here the idea is also to develop standards, and so allow companies and developers of artificial intelligence to base themselves on harmonized European standards and simplify also the process of the conformity assessment. Because we are creating an ecosystem of trust for citizens, but we are talking of a space which is also under technological development. So we have to make sure that we have the right balance between innovation and what is then the minimization of the violation of our fundamental rights.
And so going rapidly to Mr. Benifei, do you think that we should add individual rights in the AI Act or not?
Well, I think it would not be easy from a legal point of view based on the kind of regulation we are talking about. That is, has been explained already, both by you introducing now the point and also by Dr. Scioli. Okay. Sorry, because the other event I have to go is starting. In fact, I will answer maybe one question if I can, and then. So just to conclude on this point, I think that it will be. I share the general approach of Dr. Scioli on what has been just said, but I think it will be very important to check if what we have is granting an effective capacity of redress and of swift action in front of damages to fundamental rights and to the interests of citizens. I think we will need to look at very carefully if we can enlarge the scope of third-party assessment in specific cases ex ante, because I think that today this possibility is not considered enough in the present regulation because of worries about red tape, about creating burdens. But I think that the balance must be looked at very carefully.
Thank you very much for this point about ex-ante tools, because I think it's great to focus on participatory design. It's something that is already there. It's in the code of conduct that is possible to have for AI in the AI Act, but this is a very key point. If we had more time, I would spend like half an hour on this, but just going to conclusion, I will read some questions. I mean, very first question before we lose the opportunity to Mr. Benifei again. Are you optimistic about the process? When do you think we will have the final approved act, if you can foresee? Of course, it's not easy.
Well, I will just answer on this, then I will have to leave. I think that the process will probably take from the side of the Parliament the first half of next year. And I'm sure that the Council also needs the same time to take a position. Then we will have to confront our positions to find agreement. So I don't think we can imagine before spring 2023 to have a final agreement, because I think it will need at least the whole of 2022 to first have positions of Parliament and Council, and then to find agreement on the points where we will have, for sure, we will have differences. Okay,
yeah, well, GDPR took 4 years, so 2 years is still. So if you have to leave, thank you very much. If Dr. Scioli is paying, she will, thank you, ask a reply to some questions. So thank you, Mr. Benifei.
Thank you.
Bye-bye. So there are a couple of questions we cannot address all, and I don't want to exploit your availability, but I will take some. I think you also can access the Q&A tool. So, for example, there was a question by Merve Ikok about, can inclusion of biometric categorization normalize and justify these practices by the fact that they are included in the Act? So, yeah, there was this argument that was also raised. The fact that we put them at high risk is, some people were saying, if we put them at high risk, it means that if we are compliant with the rules, then we are justifying some practices. How would you like to respond? And in the meantime, I look to summarize other questions.
Okay, first of all, notice that when we talk about biometric identification, we refer very much to the use by law enforcement authorities. So the use of remote biometric identification that is done in the private world, that is in GDPR, okay? So that is already kind of forbidden on the basis of GDPR. So here we look at the law enforcement authorities because we feel that the law enforcement directive wasn't very clear on this particular point. And what we say here is that we think that remote biometric identification systems, we recognize that they can be useful for the police. If the police is carrying out investigations for our own safety, remote biometric identification systems can be very useful. However, as we know, they can also be problematic because they can be biased and they can therefore facilitate the restriction of freedoms of certain groups of our society. And we want to prevent that. So one of the things we want to do is to introduce, considering them high risk. Now, they're not as high risk as the other applications. You may have noticed that there are also some further obligations on those particular applications, but we consider them high risk and possible to use because we think that they can be useful. But by considering them high risk, we force police and law enforcement authorities to check how these applications have been built. And one of the checks concern bias, or actually concern the making sure that it is not biased and that the outcome is not discriminatory. Then, of course, when we talk about real-time remote biometric identification systems, then here is the case when the police actually uses them in public spaces to identify people on the spot and has the capability of stopping people on the spot and therefore restricting their freedom at that very moment in real time. That we consider to be an excessive restriction of freedom, so we do not allow it unless the police is looking for a criminal, or there are some exceptions that are based on the Europe on European legislation, but these are very specific cases. We think this is the most balanced approach. And therefore what we really consider important is that it is made sure that these systems work well. Of course, I have to say that we are receiving some opposition in Council, for example, because many countries think that our approach is too restrictive for the law enforcement authorities, and the law enforcement authorities should have more freedom in carrying out their investigations.
Yeah, indeed, we are sure that there are different tensions. Here we are in a privacy arena, so of course the questions that you are receiving are more for fundamental rights of individuals. So a couple of questions relate to the high risk list again. One was about, and then we have questions about certification. So I will try to summarize two questions about risks. One says, we forbid some practices at Article 5, right? But if we do it not through an AI, but we put some human in the loop, we would still be able to do those practices. Wouldn't have been better to have a general prohibition of those practices? And another one connected is how can a risk assessment work if in the future there are future risks that we cannot foresee today about AI? We know that the European Commission will amend the list, but do you think the European Commission will amend the list on a frequent frequency, or it would be difficult to amend the list?
On the first question, I have to say that this is a regulation based, addressing the use of artificial intelligence. So if you can achieve certain objectives in other ways, it is not the subject of this regulation. And so having said that, it's not that our regulation completely excludes human intervention. Actually, we consider it useful as a form of human oversight if needed. It's one of the criteria that we want to have in high risk AI. We always want to have human oversight in one way or the other. Then which way it will be implemented will depend on the specific application. But using AI doesn't mean that the human is completely excluded. For what concerns the change of our list, now we want to give legal certainty with this list. If we change it too often, we don't give legal certainty anymore, because actually there will be a lot of designers and developers sitting there thinking, I'm doing this, but tomorrow the European Commission may change it, and then I cannot do this anymore. So we will do it. I don't know how regularly we will do it. I think this is something that will be decided in this board that we propose in our act. So that will be one of those decisions that are taken in a second stage. And we will do it also with the help both of the market surveillance authorities in the member states that will have observed some practices, as well as with the help of an expert group, which will be advisory, which will also include academics, which will include fundamental rights organizations, and all those that are best placed in observing certain practices. So we are going to have to find the right balance between not making too frequent changes, otherwise we lose the legal certainty, and not making them too rarely neither, because otherwise, we want to capture them.
Yeah, thank you so much. Another point is certification. We have two questions about certification that are incredibly well linked. One is about let's say, authority that is in charge of the conformity assessment and certification release and assessment of the certification. For example, we have some AI systems that can be used in different fields. So for example, if it's used in the health sector and the authority has not, for example, expertise in that field, it might be problematic. So are you thinking at this problem of intersectorial and interdisciplinary certification? And connected to this question of certification, also the problem of how individuals can, deployers can check that the authenticity of the mark of the certification, because there have been some problems in watermarking and digital marking. So this point, certification enforcement and certification authenticity.
So these are very much questions for the Council, I have to say, because the conformity assessment bodies, the notifying bodies, as they're called, are organizations at the national level in the member states. And it is true that in some countries, for example, they are more specialized in certain areas than in others. And it is true that if we don't pay sufficient attention, and member states don't pay sufficient attention to the skills of these organizations, we run the risk of not having organizations that are up to speed. And therefore, everybody, for example, all those providing AI in a certain field, don't have a notifying body in their country. They will go to a body in another country, and then a bottleneck will be created. So we have to work very much with the member states to make sure that the skills are there in these organizations in the different fields that we target. And we will have a couple of years' time at the end of the negotiations to make sure that this takes place. We will also foresee the possibility that these bodies could actually outsource the analysis to specialized laboratories, for example, universities, or we are setting up with the member states facilities that we call testing experimentation facilities. And we are going to do that in areas like manufacturing, healthcare, agriculture, smart cities. So there you could also, for example, one could outsource some certification checks by the notifying bodies. This all has to be organized, and this can only be organized once the member states agree to the proposal and to the governance of the proposal. And for what concerns the watermarking, well, frankly, I hope that authenticity is not a problem when the certification takes place in Europe. Authenticity is often a problem when the certification takes place outside of the European Union. There are many cases, and we have recent examples with masks, for example, during the pandemic, where the certification was given in other parts of the world and then was given to Europe as if these masks were respecting certain criteria. And the problem here is that the European Union would recognize those certification systems. Now, in our AI environment, we have no adequacy decision for the moment with any other country in the world. So all the certification would have to take place in the European Union. And we will be very vigilant, at least in the European Union, we can be that the certification is authentic.
Thank you very much. We are out of time, so I wanted to say a huge thank you to Dr. Scioli. She was extremely available, and she replied to every kind of question. And I think we touched upon more or less the whole. There are more points, of course, but the time was that one. So thank you very much. Now there's a small coffee break, and after we have a wonderful panel moderated by Gabriela Zanfir-Fortuna. So thank you very much, and see you in a bit.
Hello, everyone, and welcome back to the Brussels Privacy Symposium. My name is Gabriela Zanfir-Fortuna. I am Vice President for Global Privacy for the Future of Privacy Forum. And I am very happy to continue the conversation on AI regulation. I hope everyone had the chance to refresh their coffee. I know I did. And I certainly need one because I'm in Brussels now after quite a long time and dealing with a bit of jet lag. So please, well done, Luca. I see one of our panelists also has a refreshed coffee. So I am absolutely honored to introduce the next panel, which technically comes from all over the world. We are very grateful to be joined by remarkable panelists. So I will start with Simon Chesterman because he's joining us from Singapore. Simon, thank you so much for joining at such a late hour there. Simon Chesterman is the Dean and Provost Chair Professor of the National University of Singapore Faculty of Law, and he's also Senior Director of AI Governance at Singapore AI. Welcome, Simon. I will continue moving around the world, and I will introduce Elham Tabasi. Thank you very much for joining us. Elham is the Chief of Staff, Information Technology Laboratory at the US National Institute of Standards and Technology. She is leading a lot of the AI work that the NIST is doing, and Elham is joining us from the United States, from the East Coast. Welcome.
Glad to be here. Thank you.
We will now move slowly towards Brazil, where we are very honored to be joined by Luca Belli, who is a professor of internet governance and regulation at Fundação Getúlio Vargas, FGV Law School, and who is leading the CyberBRICS Center there and doing great work around AI governance and data protection law as well. Welcome, Luca.
Thank you very much, and thank you very much for the invitation. Good morning to
everyone. And then last but by any sorts not least, I'm very happy to introduce Audrey Plong, who is the head of Digital Economy Policy Division at the OECD in the Directorate for Science, Technology, and Innovation. Welcome, Audrey. And I do believe that Audrey is joining us from Brussels. So this is why I went, around the world in this direction. So we have just heard from the European Union representatives, from the European Commission, from the European Parliament, details about the proposed AI regulation here in Brussels. And we've seen where the conversation is going here. We are talking about defining different levels of risk for AI systems. We are talking about bans. What should be banned? Should there even be bans? And about certification, ex ante mechanisms to control some of the high risk AI. But the conversation on AI regulation is actually going very, very well and very much around the world as well. And I will start with Luca, because I know that while the European Union was the first jurisdiction to introduce a legislative proposal to regulate AI, Brazil followed quite soon after. And we know that there already has been a bill that the parliament there is discussing. Luca, can you tell us a bit about that? Where are we with the procedure, and what are the key elements of the approach in this Brazilian bill?
Yes, thank you very much, Gabriela. And yeah, as you were saying, at the end of September, on 29th of September, the Brazilian Congress, the Chamber of Deputies, voted the AI bill, or the bill for an AI framework, basically, which was basically seen as a surprise by the Brazilian community, because it was adopted, well, not adopted, but it was introduced in Parliament and voted in by the Chamber of Deputies rather fast, early, and indeed only less than 6 months that since the AI strategy was adopted by the government, and during still the pandemic ongoing, and so this has not really created the best possible option for public debate. Actually, a strong criticism has been with regard to the lack of public debate with regard to this bill. That at first was introduced during the consultation for the AI strategy. So the consultation was not even finished and the bill was introduced. Then the pandemic arrived, so debate on AI was really not on the top of the agenda. And then the Chamber of Deputies voted this on the 29th of September. And the bill is a very light touch bill. It's a very concise bill, only 16 articles. It's a remarkable difference compared with the more, let's say, detailed approach adopted by the EU institutions. And on one hand, this could be interesting. Actually, the rapporteur of the bill herself specifies in the report that the bill draws enormous inspiration from the OECD recommendation, the 2019 recommendations on AI, so a principle-based light touch regulation. But it also creates a lot of side effects that may be negative externalities with regard to the well-functioning of the regulation. Why am I saying so? Because while this would be very good for adoption by the Congress, the fact it is a very light touch, principle-based regulation, and also let's contextualize. Let's remember that Brazil is entering into presidential elections in 2022. So AI again will not be in the top of the agenda of anyone and at the political level. So this will help the adoption, this quick adoption of the bill. But the bill itself being so light touch and explicitly delegating to other governmental bodies the regulation may be very complicated to implement because the interpretation of the bill will be up to the judiciary, which in any country is not really the most well informed about how AI function. The specification would be delegated to governmental agencies, which, as in most of countries, do not have any specific units dedicated to with data scientists and dedicated to understand how AI functions. There will not be a specific entity with an overall remit to implementation and regulation. So this would be this may create a lot of juridical uncertainty. And another very, and then I will stop here to avoid speaking too much about this, but a very important topic that has crystallized criticism of the entire Brazilian community is the fact that it creates also a subjective responsibility. So rather than identifying objectively which are the criteria that may identify risky AI systems, and that that would demand special regulations, special obligations, special attention from the regulator, it delegates this identification to agencies, and then it creates subjective responsibility. So the responsible is the developer, but it is up to the user, the individual who believes to be a victim of an abuse or any unduly treatment to prove it. So this is what Romans already 2000 years ago called probatio diabolica, meaning it is, I mean, we are speaking about 210 million people in Brazil that are not data scientists, that simply do not have the means to understand how AI functions, and to prove the AI does not function well, but they have been victim of any kind of discriminatory treatment. So there are some good elements in it, but also a lot of elements that really need a lot of further debate. And at this point, at this stage, the bill is in the hands of the Senate, and we still do not know how it will evolve, but we are very vigilant on the development.
Thank you very much, Luca, for that introduction. Indeed, we are seeing a bit of a mix between this detailed high regulatory approach in the EU and some of the approaches that we'll talk about in a second, where we see a lot of self-regulation or principle-based guidance that is emerging in other jurisdictions. For the time being, I will go to Elham, because I know that the United States, it's really taking a different approach to what we have discussed until now. We've seen that it's somehow more focused on self-regulation, on standards, on very practical implementation level standards from institutes like the NIST. For example, the NIST has a trustworthy AI program, and it's one of the outstanding initiatives that we are seeing in the US. So Elham, can you tell us a bit about the approach you're seeing in the US, and then introduce the trustworthy AI program that you are coordinating?
Absolutely, and thanks again for the invitation to be here. Delighted to be among the world leaders in AI. Yeah, you are right. Our approach is, at least the approach that definitely at NIST, is more technical. And I just spent 30 seconds to give a very broad overview of NIST, and that can also explain our approach. That NIST, under Department of Commerce in the US, has a very broad portfolio of research. Our scientists at NIST do everything from building the world's most precise atomic clocks to working in bioengineering, developing standards for use of robots in manufacturing, to mathematical modeling for the fires to help the behavior of the wildfires, which eventually helps firefighters. And in all of this, NIST has a long-standing reputation for cultivating trust in technology. And that's exactly what we are trying to do in the field of AI, and the driver and purpose for the NIST Trustworthy AI technology. We agree with almost everybody and many in the world that AI has potential to positively augment efforts to uplift and empower people, yet it comes with certain risks, and some new risks and some existing risks to individual organizations and societies. We welcome all of the discussions on the principles for trustworthy responsible AI. OECD is a leader on that, and the principles that they developed is being adopted by many countries, including US. The opportunity that we see is to operationalize these principles, kind of translate them into from principles to practice, into the technical characteristics and attributes that different AI actors, if the designer, developer, evaluator, auditor, policymaker, and regulator can use to understand and assess the risk. And I'm going back and forth between risk and trust and trustworthiness, because we see them as the two sides of the same coin, that by diminishing, decreasing risk, trust and trustworthiness increases. We also got a mandate from US Congress to develop the AI risk management framework. And we were given a timeline that by January 2023 to have we call it a completed version 1, because we believe that the work is going to be continued. So what we're really trying to do is, in development of the AI risk management frameworks, many of you that are familiar with NIST, is that we plan and carry out our work in close collaboration engagement with the community. We invite everyone in academia, industry. We work with the standard development organizations in advancing this. And so what we're trying to do is, again, to come up with, we call them core building blocks of the trustworthy AI, or, taxonomy of risk. And based on the discussions and engagement that we had with the community, we posted the taxonomy of AI risk right before the workshop that we held on October 19. What are those elements? We want the system to be accurate, but beyond that, we want the system to be resilient to different vulnerabilities, privacy preserving, robust to data and condition environment not seen during the training. We want them to be reliable. We want it to be safe, interpretable, and explainable. So what we had done by this, again, in work with the community, we had to try to translate topics such as harm to human well-being, harm to human rights, get these high-level principles, which are all great and good, bring them down into criteria and characteristics that could be designed in, implement, develop in AI systems, but more importantly, used to test them. What's our approach? Our approach is, again, work with the community. We had a request for information. We get a lot of response. We held workshops. We're working on drafts to put out, again, engage the community, hear their comments. So that's about the process. In terms of the technical approach that we are taking is basically come up with, as I said, the core building blocks. The document is out. We are still revising this based on the inputs from the community. So the first thing we need to know is what's taxonomy of risk. Then for each of those components of risk, we need to develop a vocabularies and terminology. It's often the case that we use the same term meaning two different things, and because we are working with we are hoping for a very broad audience of this risk management framework, computer scientists and mathematicians, all the way to psychologists and sociologists and lawyers. Even terms such as bias may have different meanings to these different groups. So after coming up with the taxonomy of risk, we're working with the community to come up with a shared understanding of each of those terms means. These two gives us a good foundations of what it is that we want to measure. And that's when we start working, or in parallel to that, we start working on development of the metrics and methodologies and test beds and benchmarks for assessing each of them, and also understanding the interactions among them. So these are going to be components of the risk management framework. And during this, as I said, we want to make sure that we work with researchers, technology developers, standard development organizations. And last thing that I would say is that NIST is a non-regulatory agency. And certainly the work that we are doing, the framework that we are developing is going to be for voluntary use. It's going to give, we hope that, we do it right. So it gives the right information for evidence-based policymaking and for regulations, right? We just heard about certification, for example. So when you want to certify, you certify to some specifications, and the work that we're doing, I hope, is giving those specifications in technically sound, scientifically valid manners that allows for clear, implementable, and testable requirements. I went over my 5 minutes. I apologize. Happy to answer any questions.
Thank you so much, Elham, for that wonderful overview. Indeed, we're seeing a very practical approach, an approach that's very inclusive in the sense that you are talking to stakeholders involved in different ways in developing AI systems and putting them on the market. And a self-regulatory approach, as we call it, among us policy wonks. So I'm going to move to Simon now, because we have heard about legislation, very detailed, legislation, principle-based, that has room for self-regulatory approaches as well, and then quite effective and technical in the end approach that we're seeing proposed by the NIST. What is the landscape in Asia? And I know this is a very, very broad scope, but I know that Singapore has a very interesting approach. We are also starting to see draft regulation targeted at algorithms coming out of China, for example. Are there commonalities throughout the region? What are you seeing there?
Yeah, thanks very much, Gabriella. And good morning in the Americas, good afternoon to the Europeans, and good evening if you're in Asia like me. So I might answer your question in two parts, focusing on the kind of why regulate and when to regulate. And I think there is some commonality in Asia, but it's primarily in its distinction from what's happening in Europe and in the United States in particular. So in Europe, you've had very much a rights-driven approach we heard that in the previous panel, that it's how to safeguard the rights of individuals, in particular those within the European Union. The United States, one reason for the strong push on self-regulation is that the dominant actors in the United States are often the technology players themselves, that they're the ones who have a lot of leverage, they're defining a lot of these standards through their actions. And what's interesting in Asia is it tends to be governments that are acting, not because of agitation on the part of individuals championing for rights, although there are some people advocating that, nor even because of companies lobbying for particular activities, but it's governments trying in many ways to reap the economic benefits of artificial intelligence and minimizing some of the risks, but maybe making a slightly different calculus to that which we've heard about in the United States and even in the United States or Britain, or as opposed to the European Union. So that leads to the when question, when to regulate. So you mentioned Singapore. Singapore has a model AI governance framework that is not even really self-regulatory. It's at the level of principles. We had a review of the penal code where the report explicitly said we're not going to change the criminal law to deal with AI because it might constrain innovation. And in that sense, it's quite similar to the position in China a few years back. China in 2017 adopted a national strategy on AI, which said, right, we're going to invest in this technology, we're going to develop it. And yes, regulation might be important in perhaps 2025. Now, China has moved a bit more quickly than that. We've seen this year the Personal Information Protection Act coming into force just this month. So China is moving. But on this when question, I think many jurisdictions are wary of constraining innovation or driving it elsewhere. And this is where all countries around the world, all jurisdictions, face a dilemma. And probably the easiest description of this, some of you may have heard it before, is framing it as the Collingridge dilemma. This dates back to a book published in 1980 by David Collingridge on the social control of technology. And basically the dilemma is this. At an early stage of technology development, it's easy to regulate. It's easy to impose controls. The costs are low, but you don't know what costs, you don't know what controls to impose. You don't know what the risks are. If you wait, the risks become clearer, but the costs go up. And this is really where we are with AI regulation. And candidly, I think the Europeans are proposing to regulate much harder, much earlier. And the danger is that you don't know what you're regulating, or you're imposing restrictions that will just drive innovation elsewhere. The danger in Asia, if you like, is if you wait too long, then the risks when they materialize are too hard to pull back. And we can illustrate that, for example, with social media, that if back in 2004, when Facebook was just being launched, it would have been easy to regulate Facebook back then. It didn't have a lot of market power, it didn't have a lot of influence, but we didn't know what the harms were. Jump forward to 2021, and it's much harder to regulate that. It's much harder to put, if you like, the genie back in the bottle. So maybe one last thing is to highlight an obvious distinction, that the sensibility of rights, arguments about privacy are quite different in Asia. That's not to say that Asia is homogenous. It's not to say that Asians don't care about privacy, but the debates are quite different. They're much more nuanced. They're much more, much less strident, perhaps, than in the European Union, for example. And indeed, that's one of the reasons why China has become such a powerhouse in AI, because one of the key factors in AI development is access to data, and China has a lot more data, including personal data. And it is interesting that it's only this year that China has started to impose limitations on the collection of personal data and started to try and rein in some of those technology companies. So all this to say, yes, the debate is quite different in various Asian jurisdictions, but I think we're all learning by doing.
Thank you so much, Simon, for that that overview. It's for me, it's really fascinating to follow what's happening in Singapore, China, South Korea, Japan, in data protection regulation, but also AI. I am moving to Audrey now because she perhaps has the toughest job for the, working at the OECD. She has to work with all of these jurisdictions and all of these approaches that Simon beautifully showed are quite different, focus on different things, I would say. Audrey, we know that the OECD adopted a framework for responsible AI 2 years ago, if I'm not mistaken. Can you give us some insight into that work? How were you able to find, agreement among different approaches to adopt the principles? And if you can also tell us a bit about the state of implementation. We already saw that Brazil took some inspiration from them. So I think that's good news for your work, right?
Thank you, Gabriella. Hi, everyone. It's great to be with you. It is very exciting to hear about Brazil's use of the AI principles. They've also adhered to the recommendation. They're not a member of the OECD yet, but it goes to show that our work does go much broader than our specific membership. So I guess I'll spend only a very little time on how we got to the recommendation, because in some ways I think what's happened since then is it's not maybe more interesting, but it's probably what people are more interested in at this point. But I think, the OECD, there was a moment where I think people were ready, both politically and substantively, to say that, we needed to put a human-centric, rights-based view on this technology. And fortunately, the team at the OECD that preceded my taking on this role stepped into that open door and helped drive, a consensus. They're high-level principles, as many AI principles are, but they were the first, or are the first, intergovernmental standard that was agreed on how to put, a human and rights-based approach at a policy level. So we're very proud of that, but we haven't stopped there, as I'm sure you know, because high-level principles are important, but what you do with them is equally, if not more important. And so I'm really pleased to say that our work has grown significantly in the past 2 years. I could spend all day talking about the contribution that a very large group of experts, many of whom I see involved in this event today, have been involved in helping us drive forward. But I want to just highlight, I guess, maybe 3 things that we're doing before we go into more of the discussion. One is a framework that we have been working on for quite some time on how to classify AI systems. And everybody is talking about, sort of where to draw the regulatory line, or what type of policy line to draw about different types of AI action. And we're trying to help put a baseline standard in place for how governments and really anybody, but we're really targeting policymakers, think about and in a systematic, standards-based way classify what a system does. And we think this is important because it leads to the ability to better assess the risk. And so as we, one area of commonality across many jurisdictions, at least within the OECD, is that we should have a risk-based approach. And then we sort of the devil's in the details of what that means. So at another time, I could get deeper into what the framework is. There's 4 elements of it for assessing assessing what a system does, what an AI system does, as an input. But I'll save that maybe for the deeper conversation. I guess the second thing I'd focus on is the work that we have to identify tools that AI actors can use to make sure that AI products are developed in a trustworthy manner. So we have a analysis that is coming out that, or has just come out, that breaks these tools into 3 different categories: technical tools, procedural tools, and educational tools. And we're cataloging these tools, and they'll be available on the observatory. I'm sure many of you are familiar with the observatory, but if you're not, please go to oecd.ai. And we're trying to make this data and these databases and this information user-friendly, appealing, and accessible, so it's easy for both policymakers and practitioners to look at what their options are there, and to keep this this kind of information up to date. And then finally, another important piece for us is embarking down the path of developing a global AI incidents tracker. So we're in the process of developing some partnerships and working with our committee and our working parties on looking at incidents and figuring out how we can take those incidents and what we can derive and learn from them in terms of a feedback loop to what does that mean for risk and what does it mean for the systems that we classify. This is all in the spirit of trying to take that harmonized, as much of a harmonized or interoperable approach to understanding the challenges and the risks, even as we recognize that, you know, again, regulatory lines and policy lines may get drawn in slightly different places based on domestic imperatives, culture, legal regimes, and whatnot. But that if we're all coming from a similar starting point and using, as other colleagues said, similar terminology and all of that, we have a better chance of having, you know, interoperable policy frameworks that will support innovation and the responsible use of the technology. So, thank you.
Thank you very much, Audrey, for that overview, and frankly for the work that you are doing. I think some of the tools that we've just heard about are going to be extremely important for the jurisdictions looking at how to deal with AI. I have a second round of questions prepared, but I would like to launch a call to our attendees to please put your questions in the Q&A already. I will try to maybe incorporate some of them. So we're hoping to make this as engaging as possible. Luca, I'm going to you now with a question that is going to be very dear for you, I'm sure, because it's also for me. I actually came to look at AI regulation through my data protection law perspective and lens, because at the very beginning of this field, the machines and how the machines use data and this idea of a computer was what really made parliaments in Western Europe and, you know, lawmakers, policymakers in the US react. Brazil has adopted recently the general data protection law there as well. And somehow, you know, it already applies to some of the AI systems that are being developed and how they use personal data. My question for you is, how do you see this overlap? To what extent the general data protection law in Brazil already applies to some of these systems, and are you seeing a conversation going on there? And feel free to talk about the CPDP LATAM as well, because I know this is one of your focuses for the conference.
Yeah, thank you very much, Gabriela. Yes, and just to contextualize a little bit, besides my hat of director of the Center for Technology and Society here at FGV, I've also initiated, together with a lot of friends that participate today to this conference, the Latin American version of CPDP LATAM, that was held for the first time online this year. And then I've also been coordinating this project called Cyber BRICS that compares digital policies in the BRICS countries. So I will try to provide a reply to you, not only focusing on Brazil, but also on these two very diverse geographical dimensions, all in 3 minutes. So the first very important point is that I think that we have 2 key tendencies that are clear. One, also the AI bill itself mentions the need to apply the bill in conjunction with the existing LGPD. LGPD is the acronym, of the Brazilian GDPR. Lei Geral de Proteção de Dados. So the bill itself mentions the need to apply the law in conjunction with this, recognizing somehow that personal data in general, and personal data in particular, are the raw material thanks to which AI systems are frequently developed. Now, this means that the law, the general law, already provides some very important tools for the data subject, and also some very important obligations for those who implement AI systems based on personal data. Not only speaking about transparency, which is also reiterated in the AI Bill Article 5 as a key principle, and the right to have meaningful and clear explanation is reiterated. And it is also stated by the LGBT, but is reiterated again by the AI Bill. But a lot of other obligations that already exist, not only in Brazil. And if we take a wider focus in Latin America, we have analyzed several legislation in Latin American countries, and there are these key elements, principles of transparency, security, fairness. They are common to the Latin American countries that usually copy and paste, or let's say take a lot of inspiration from the European model, right, in regulating personal data. So there are a lot of tools that are already at the disposal of the individual, and then regulate how personal data must be processed by controller or processor. And this is the optimistic part, and the optimistic tendency, the good tendency. The bad tendency, and that we also have analyzed at CTS 11 national frameworks in Latin America, and we have seen that it is very much utilized for public safety purposes, AI, especially face recognition in Latin America. And usually this public safety, law enforcement, national security are excluded by all the laws. All laws create a very ample exception, even when there is very sound data protection regulation, copied and pasted from the very golden standard, the GDPR, there is very ample exclusion of this. So what is the tendency in Latin America is to import only part of the framework. Because when Europe adopted, GDPR also adopted the Law Enforcement Directive 2016-680, which regulates precisely how personal data are utilized by law enforcement. This has not been implemented in virtually any Latin American country. So, but that is the area where artificial intelligence and especially face recognition systems are most utilized. So it's a completely gray area. The Brazilian government, just to give you an example, created at the end of 2019 an enormous public database cross-referencing personal data of virtually all Brazilian citizens for law enforcement purposes. So that is a cause of concern. And then the frustrating part is that I somehow recognize that as a lawyer, that law is a very imperfect tool of regulating society. There was this very famous quote by von Metternich about the sausage factory, right? Like both laws and sausages, you don't want to know how they are made. But then it's also the worst part for me is the implementation, because what is Brazil is very telling example is that if you do not carefully craft the implementing side of the regulation, it's not very useful to have a very nice law, but that will not be applied in practice. The Data Protection Authority, to give you an example, in Brazil, that has been created exactly 1 year ago, is not only dependent from the Brazilian presidency, so it's not really it's not an independent authority, but has a staff of 36 people. 36. To give you an example, and then I will conclude, as I also used to analyze BRICS policies. In China, the cyberspace administration of China has 60,000 staff members. Of course, the remit is quite different, and the population is quite different, but is in order of magnitude of almost 2,000 of difference, right? The Chinese the Chinese authority is almost 2,000 times larger. Of course, there are some differences, but to me, the Brazilian authority, it has been conceived not to effectively regulate a very important part of what will be the development of Brazilian society and economy. And it will not, as it stands according to the AI bill, it will not have competence to regulate AI, only for some marginal extent. So this, in my vision, creates even more confusion and somehow reduces the beneficial impact that the AI bill could have.
Thank you so much, Luca, for this very thoughtful answer, and actually for bringing into the conversation the role of the law, the limit, actually some of the intrinsic limits of the law, because you were talking about laws that exclude from their scope national security, public safety, and other specific areas. This will bring me to Simon, actually, because the question I had for him, the answer might be a very nice segue from what you just said. So Simon, very recently you published a book with the robots, and that's where you explore precisely the limits of the law when it comes to regulating AI, or looking at AI as the object, of legal regulation. What are some of your main conclusions there? Are you seeing some of the limits in practice also in Asia, the limits that Luca was mentioning earlier? So what's the conclusion?
Okay, well, so in 3 minutes, I'm going to just put a shameless plug for the book. If people are interested, they can look at that, and I'll limit myself to 2 points. Because limits of the law works both ways. And basically, I think around half the book is saying you do not need new laws to apply to AI. I think there's a really disturbing tendency to act as if we need to come up with new rules for these new entities. I blame Isaac Asimov for part of this, because he had his 3 laws of robotics. People forget he was a good science fiction author. He was a terrible legislator. His laws didn't work. Most of his literary career was about how his laws did not work. So the first point to raise is that, and what I argue, is that the limits of the law, actually much of AI can be regulated by law. And indeed, this goes back to something in the previous panel, where one of the questions was, well, you shouldn't be able to do through AI something that you can't do yourself. And a lot of the discussion about regulation is saying, okay, AI should be accountable. AI shouldn't be discriminatory. AI should be safe. AI should respect privacy. That's just another way of saying that the people, the natural people, meaning humans or the corporations, using artificial intelligence systems should be bound by the same laws as everyone else. The question, I think it was Elham who highlighted this, that the devil is in the application, how that actually applies in practice. So that's part of the book. And then the other thing that I hope is useful is that, okay, when the law is stretched, when it does get beyond what we can deal with through existing legislation, what are we trying to achieve? I think the risk-based approach that some people have been talking about is important, but I actually think you can separate 3 different reasons why we want to regulate AI outside of the normal law. And the first situation is where we just want to minimize harm. We want to get the best outcome. We want to optimize. And AI is quite good at that. Autonomous vehicles, we just want them to be safe. And so I don't think that's particularly complicated, and law can help allocate losses appropriately. You can mandate insurance and so on. So that's a practical consideration. Secondly, however, there are areas where I think we want to draw moral red lines and say, no, a human should take these decisions. And this is the kind of human in the loop situation. That won't always be because the human will make a better decision. I mean, I believe, for example, lethal autonomous weapons should be outlawed. Humans should be making life and death decisions, not because humans will make better decisions, but because these decisions are hard. A human should have to grapple with the moral difficulties, and then a human should be held accountable for them. So that's a second type of consideration, that some situations just optimize, some situations you want a human to make a decision. And then lastly, there are some situations where you want a particular human to make a decision. And this is in particular public sector decisions, the role of judges, the role of political officials. Their decisions are legitimate, not because they're geniuses, not because they're human, but because they operate within a political paradigm. And if the people don't like the decisions that are being taken, then you can vote that person out, or there's a process for changing them. So those are some of the arguments that I've at least found interesting and I've written about. But I'll stop there to not cut into other people's time and hopefully leave a bit of an opportunity for Q&A.
Thank you very much, Simon, for those insights. Elham, I'm going to you now, and I will incorporate, in fact, some of the Q&A from the Q&A thread here, because we unfortunately don't have so much time left for the panel. We have a question from Cam Carey, our friend Cam Carey, who asks if you can compare the NIST taxonomy and the risk management framework with assessment frameworks that we are seeing, for example, in the EU AI's regulation, like the conformity assessment, and perhaps at the EU high-level expert group as well. Or maybe not necessarily to compare them now. I would actually ask, are you having conversations with those proposing those frameworks here in Brussels? And is there an opportunity to somehow make them work together? Give us your thoughts about that.
Okay. First, hello, Cam. Thanks so very much for your question. Engagements, yes, as I said, engagement with many different levels, again, researchers, technology developers, standard development organizations, policymakers, is essential in the success of what we do, not only for this AI risk management framework, but in everything we do. And we have learned that that's really, really important. Specific answer to Cam's question is that Cam, if you're asking about the taxonomy of risk, the draft document that we put out as sort of a discussion pre-workshop, and I will put the link in the chat and email it to you, Cam. We did a walkthrough between the taxonomy of risk, which I sort of listed here 30 minutes ago or so ago. In the document, we actually categorize them into technical criteria, the technical requirements versus social technical requirements versus principles. And I think that's, we did it in terms of how we can do the assessment completely automatic, machines and algorithms can do the evaluations versus where some human intuition and insight is needed to interpret the results. I think there is some clarity with what Simon just said about bringing humans in the loop. And so short answer is yes, we have to engage. And we all know, or at least personally, I think it would be not good or maybe even close to a failure if you develop a risk management framework that is sort of orthogonal and in contrary to other documents that are going on. Let it be standards being developed within ISO and IEEE to the policy documents from EU, the documents that OECD is putting out. So definitely engagement is really important, and our goal is to align to the extent possible with all of them. But also more importantly, just leverage them, right? The things that has been done are good. We don't need to do them again. We can just build on top of them. So yes, engagement is important. Are we doing enough? We're doing some of them. I'm sure we can do more. That's why I'm extremely grateful for this opportunity to make more connections. Please let us know. Please contact us in our website, and I put it in the chat how to contact us, and always email me. And answer specific to Cam is yes, we want to make sure that there is a kind of mapping from all of them, and I use it as sort of a design principle as we're developing the risk management framework to make sure that we are not going too off from other ones. If I can have another 30 seconds to answer questions from Dan on the question and answer that. Yeah, I would. That's what I had in mind. So. The question is about, first of all, thanks for your kind words. The question is whether we believe that there is a feasible way to measure topics such as bias and discriminations in a meaningful and agreeable way. So that's exactly what we're trying to do then, to get topics such as discrimination and bring it down to criteria and characteristics that can be testable in a technical way. So can bias be tested? I would say yes, but first we have to agree what biases we mean. And we put a document out back in, I think, July. It's special publication 1270, a proposal for managing the risk of bias in AI. with many things that we do for the AI. We start with the terminology and taxonomy and mapping those type of risks to the life cycle of AI. We received a very broad set of really good comments. We are talking with the people that commented on that document to develop the revised draft, and again, holding more workshops around this with the goal of exactly what we said, to come up with a meaningful and agreeable way to measure bias. But before that, we have to have a meaningful and agreeable definition or understanding of what bias is. And I think that's half of the battle to develop that. So extending the invitations for engagement, conversations, talk to us, help us to do this. Thank you.
Thank you so much for that and for taking a couple of the questions that we have here lined up. And I'm going now to Audrey, and I will incorporate another question from the Q&A before finalizing the panel. So we have a question asking, when looking at AI legislation, where do you draw the line between AI and machine learning? And I know that the OECD, as Audrey just mentioned, is already doing some work in that respect, because we have a framework on how to classify AI systems, right, in the works. So Audrey, can you tell us a bit about that and what's next for the OECD with the AI work?
Sure. I guess in short, I would sort of, in answer to the actual question, say that I think people tend to use AI as just a very broad category to mean machine learning and eventually actual artificial intelligence. So I don't know that we're specifically trying to define a distinction between AI and machine learning. I think it's interesting to see whether it presents a problem and a definitional problem that we should be trying to address, and maybe others are that I'm not aware of. I think so. I think it's a great question, and I sort of take it. I take it on at sort of face value that people tend to actually mean machine learning at this point and where we are in the sort of technology development and use cycle more than actual more developed artificial intelligence. But with regard to our classification framework, it's really more focused. It's a little bit more in the weeds, if you will, in terms of it's less about definitions of terms and more about how to figure out what the system is doing. And so I'll just very quickly, because I know it's sort of at the end of the panel. We have four contexts, so 4 elements. I mean, the first is context of the system. So this takes into account the sector in which a system is being used, the scale of its deployment, the type of users that interact with it, and the degree of choice that they have in using the system. The second dimension covers data and input. So it looks at data that flow from the context, so from the environment into the AI system. It considers where the data comes from, what kind of data they are, whether rights are attached to those data, like privacy or intellectual property. A third dimension is the model itself, the AI model itself, and this is made up of the computational representations of everything that takes place in its context. So we look at the model as a whole and the many technical elements that it's made of. It includes things like the type of models and the type of training methods used in the system. And then finally, the fourth dimension looks at the task that the AI system performs or its output. We have a nice sort of graphic that sort of explains this more, and it's a little bit easier to digest that way. But it's sort of, the output section is what the system produces, recommendations, predictions, and the level of autonomy that the system has. And so when you put all this together, and we've run several AI systems through this classification, actually a lot of them, with a series of experts, and all of this data breaks down into a fairly robust sort of spreadsheet in which you can sort of see what you're dealing with. So I'll stop there. I know we're short on time.
That's really wonderful. Actually, very interested to see how this work will look like, and I think everyone attending has the same feeling about it. Thank you so much. I'm incredibly grateful to have had this conversation with the 4 of you. Thank you for participating so late, Simon. Again, we apologize, and we promise we will make it up somehow. And thank you to all of our guests. We will take 5 minutes coffee break, and then we are waiting for all of you to be back with your refreshing coffee. and listen to our last panel of the day, which is another stellar panel. We promise we will discuss some of the to ban or not to ban certain AI uses question. So 5 minutes break and we will be back. Thank you all.
Thanks, Gabriela. Thanks, everyone.
Thanks, everyone.
Hello, everyone. Thank you for staying with us in such a big number. We are very grateful. And you know how they say that you save the best for last? We do have a fantastic last panel of the day, and I'm very happy to introduce Ivana Bartoletti, who is the co-creator of Women Leading AI. Ivana, I'm leaving the floor to you to introduce the panelists.
Thank you so much, Gabriela, and fantastic to be here. Fantastic to hear so many of the very important conversations that we've had so far. Now, not because I'm biased, but I do think that this is an amazing panel. And I also think that we're going to touch upon some of the most controversial and debated issues out there. Should we ban? Should we not ban? And I think we've heard a lot about this over the last few months. There's been a lot of discussions, for example, around whether introducing some of the concepts, and I know we've been talking about this in the previous panels as well, but whether introducing high risk means by de facto legitimizing some practice that should be banned. And in particular, this we've heard a lot of discussions around facial recognition technology, but also I have to say a lot when it comes to employment and algorithmic management of work and performance. So whether these issues like that should be possible, whether whether they need another different approach, for example, more focused on employment legislation than anything else. And we've heard a lot of discussions around emotion recognition and a lot of these things, and are we actually opening up the floodgates to a lot of applications under the banner of high risk and potential and some controls wrapped around them. So we'll be discussing all this with a stellar lineup, some of my heroes in the space of privacy. I'll introduce you all of them. Actually, I'll do it one by one, if that's okay. So you'll have the surprise for who's coming next. So I will start with Theodore Christakis, who's Professor of International and European Law at the University of Grenoble, and is member of the French National Committee on AI Ethics. So Theodore, it's lovely to have you here. You are doing a lot of work in this space, and particularly I would like us to crack on by starting with one of the most discussed issues in this space, and this is facial recognition technologies, which is creating a huge debate out there, often confused and intertwined with discussions around biometrics, which sometimes is not helpful. And they're also creating a lot of discussions around how this kind of technologies reshape and change the way that we inhabit our public spaces. I know you're doing a current project mapping the use of FRT and also mapping what the reactions may be to it. So it would be great if you could provide us an overview of that. Thank you.
Thank you very much. Ivana, indeed, facial recognition is raising very important questions about really societal choices. And there is a great interest about this issue in Europe and worldwide. You know that in Europe, we have this very strong campaign, Reclaim Your Face, for a total ban or calls for moratorium. And on the other side, people from the security field who are saying that if we introduce necessary safeguards, facial recognition could be very important to enhance security, fight crime, improve services. And there are also calls not to hinder innovation in Europe. So there is a clear need for a debate in Europe on this issue, but as the French Data Protection Authority, the CNIL, emphasized, I quote, to ensure an informed debate, the terms of the debate must themselves be clear with an understanding of what facial recognition means. This will avoid confusion between different uses of this technology where the issues raised are not the same. And the CNIL also added, behind the catch-all term, there are multiple cases of use, and it is vital to apply a use-by-use approach. What we see in reality very often in this debate is that people talk about everything at the same time. And I don't think we should be lumping every use of facial recognition in public spaces together. So with some colleagues at the AI-regulation.com chair, with support from the FPF, we undertook the Herculean task to try to map the uses of facial recognition in public spaces in Europe, and to propose a clear classification, to provide accurate information about existing projects, past existing or projected projects of using public space in Europe, so that we will be able to inform this debate. We have developed two tools. The first tool is a rigorous classification, which is based on both on technical characteristics, technical functionalities, but also specific applications. So have identified 5 big technical functionalities and 12 applications. We think, we are convinced that when we talk about this issue, we should really go category by category. It is necessary. We are all scared about the use of biometrics in general, but banning some particular uses does not mean that all uses of facial recognition in public spaces should be prohibited. If I take an example, a use of one-to-one face verification at the airport, like the Paraf system in France, you see that, for instance, it is deployed with respecting all the data processing principles, purpose limitation, storage limitation, data minimization, and they got a very clear approval by the French DPA, the CNIL. So one should ask, why should we ban, for instance, such a use of facial recognition in public space? We should focus instead on some other categories, for instance, which are much more problematic. The second tool that we prepared was an analytical framework and questionnaire, which means a very analytical set of questions about the facts and technical details of every use case in Europe: where, when, who, what exactly was done, was there a database, how this database is created, etc. And then a second set of questions, which is about protection of human rights and data processing principles, especially we try to find every available information about the legal basis invoked by the data controllers and what was the position of the DPAs or the courts in Europe about this legal basis, what about necessity and proportionality, what about all the different data processing principles that we find in the GDPR and the Law Enforcement Directive, for instance. And then we also introduced in our questionnaire a series of questions about how the data controller took care of accountability, transparency requirements. Was there a DPAI? Was there an evaluation of the effectiveness of the system, by whom, etc.? So on the basis of these tools, we identified 100 cases, more than 100 cases of use of facial recognition in public space in Europe, and we selected 25 emblematic cases that we have analyzed in detail. What we have found is an impressive number of DPA's positions, an impressive number of courts' decisions, of DPAIs, of proposed methodologies, and we think that we have a very important case law, for instance, concerning Article 9 of the GDPR. I will just here in the 3 remaining minutes we will publish our results shortly, just a few highlights. First highlight, existing law seems to be enough to deal with at least some of the categories in the use cases. If we take face verification, I referred to the Paraf system in the airport, for instance, this does not mean that this use case is not problematic at all. It is problematic. For instance, it depends how you use it. In the south of France, there was an experiment trying to use face verification in high schools. And the French DPA said, sorry, it doesn't work. It's illegal under the GDPR because consent is not workable here with the pupils because they are under a relation of authority with their school. So we cannot have informed consent here. And there was a huge problem also of necessity and proportionality. But for this, you don't need to ban in general face verification in order to deal with this. The existing law, we have an impressive case law of DPAs around Europe about face verification. there is no need to ban. So this is why we think that we should really focus on a use-by-use case approach. A second highlight, in other cases, it seems clear that the current regulatory framework needs to further interpretative guidance and precision and even development. We have worked extensively, for instance, on Article 10 of the Law Enforcement Directive, you know, about the use of facial recognition by biometrics by police for law enforcement purposes. Article 10 was something very important, prohibits the processing of biometric data unless if some conditions are present, especially strict necessity. This is very important. The meaning of strict necessity in Article 10 of LED, and an authorization by EU or member states law. I could give you some details afterward to show you divergences between the member states concerning the interpretation of Article 10, and this is absolutely not satisfactory. And from this point of view, we can understand the European Commission, their approach in the AI regulation, where they insist about the fact that for this kind of use, we really need to do more. We need more precise guidance. We need specific laws, even though we are not convinced with their insistence on the criterion or on the time, you know, the real and the post, which is not the most important for us in a risk assessment approach. And the third, the final highlight, as I have just 45 seconds, Ivana, we see that in other fields, there are important divergences between DPAs and tribunals in Europe, especially concerning Article 9 of the GDPR. Let me give you just one example, and I will finish there. A lot of private actors in Europe tried to use, you know, the GDPR in Article 9 prohibits processing of biometric data unless if you can invoke an exception under paragraph 2. And the exception that often some private actors tried to use was the necessary for reasons of public interest exception. Especially this was used in a great number of cases by private actors in order to enforce ban lists of persons who are not allowed to enter a venue. For instance, it was used by supermarkets in Spain, the Mercadona case, and both the Spanish DPA and the Court of Appeals in Barcelona said, no, you cannot use this exception for a number of reasons. Same thing in the Netherlands, a supermarket chain tried to use this basis, the public interest, to enforce shopping bans using facial recognition. And the Dutch DPA responded exactly in the same way as in Spain, and also poked some fun with a supermarket, saying that the only example in the Dutch law is for the security of a nuclear power plant that you will be able to do this, and preventing shoplifting is of completely different magnitude than preventing a nuclear disaster. Same thing in France. The CNIL took a very strong position against using facial recognition to enforce ban lists, prevent people from entering in the stadiums who are banned from entering in the stadium. And then suddenly you see, for instance, that the Danish DPA, when it comes to another case, the Brøndby case of a football stadium, which did exactly the same thing, they said it's okay to use public interest, for instance. Or in the UK, for instance, some supermarkets are doing this systematically, and they do not even bother invoke the public interest derogation. They just use the legitimate interest legal basis under Article 6 of the GDPR, also, although this is not an exception under Article 9. So these are just a few highlights, and we really think that this study could be very useful for the debate, so stay tuned. Thank you very much.
Thank you, and definitely, I mean, keep us all posted and on the outcome of this. And I mean, you're right. I mean, there are two things in my view, and this will link me to Frank. One is the fact that we have seen over the last few months, especially with the pandemic, you know, it's been this idea that, you know, there has to be some trade-off between sort of privacy and security, whether it's privacy and security or privacy and health. And I think this is changing a lot of the perceptions that people have around this. And I think we need to take into account the fact that, you know, the perception that individuals have around facial recognition is shifting. The second element, which I think is really important that you mentioned, is that we need some clarity on what we're actually talking about. And sometimes the fact that the clarity is not there is definitely not helping. And I want to move on this. I want to move to Frank, and we all know Frank. Frank is a professor of law at Brooklyn Law School, and because Frank, you've been working on these issues for a long time. And I just wanted your opinion around this debate, you know, ban versus not banning, and the different nuances that you're seeing in the discussions between sort of the European Union and the US. You've also proposed the idea of, you know, considering high risk and AI, and the idea that, you know, to be able to create that sort of like a system of trust that we were discussing earlier, that, you know, there should be a role to say, okay, to do some ex-ante enforcement and ex-ante controls and checks to a sort of licensing agencies. So I just wanted your opinion on all this, and in particular focusing on whether this sort of a licensing agency would be able to perform that role, and to move on beyond the discussions around banning and not banning. I mean, does it make sense? Is that this kind of the kind of thinking you're having at the moment?
Great, thanks so much for those excellent questions, and I really it's a tough act to follow, going second after such a great discussion of very specific cases that have just been percolating up in different jurisdictions. And I think that essentially, you know, where I would come out on this based on some work that I've recently published with the Knight Foundation on licensing use of data. And then also with work that I'm ongoing with Gian Claudio Maglieri on AI, and particularly looking at the framework within Europe, is to say that, yeah, I think we can move beyond, or if not move beyond, we can at least help develop a rapprochement over this ban versus non-ban debate by thinking about the licensure as tertium quid, as this third thing that could come in between those two. And the way that I want to think about this is to say that I think that the major disappointment for many of us who have been following data protection and privacy law for decades is that there are so often very grand aspirations in initial legislation or in regulatory initiatives, but that rapidly it just seems that there is so much going on that it's very hard to actually keep up with the landscape of change. And we always get this sort of pushback as those either who are regulators or advocates of regulation, that technology moves too fast for the slow pace of government to respond to, you know, what Hartmut Rosa calls the acceleration of time, the social acceleration of time. And I think that, you know, in thinking about this possibility, I mean, just to ground the discussion a little bit, you know, we have in the proposed regulation on AI, the EU AI Act, different categories of risk, at least 4 categories of risk. One being unacceptable risk, which would involve, say, manipulation leading to psychological or physical harms, or based on age or disability vulnerability. Okay, so that's an initial version of unacceptable risk. So for example, there was once a story about digital marketers in the US who would try to market cosmetics to people when they were feeling at their least attractive. And I think that might be banned, you know, that sort of a thing, which I think is an interesting sort of element of this. Also, a decontextualizing or unjustifiably detrimental social scoring system. So I think that's a very interesting idea, sort of looking at the social score, because we realize that at least in the sort of discussions of the possible applications of a Chinese social credit scoring model, a lot of concern was raised over the possibility of a score that could try to commensurate one's, say, trustworthiness or value over different areas of life. And I think that is a very interesting sort of unacceptable risk category. And then finally, indiscriminate facial recognition by police being one of these other unacceptable risk categories in the proposed EU AI Act. And then beneath that, there's high risk, you know, where there's credit scoring, AI used in critical infrastructure by judges, public administration, or police, products under safety regulations. And there are certain design duties imposed. But I think the worry is, and that certainly was a worry that I think was expressed in the critique of the EU AI Act by Michael Veal and Frederick Borgesius was the concern that essentially the standards bodies that were being deputized to be putting this into place may not be able to really, either that they're may not be adequately prepared, or that the resources available or expected of the member states, say allocating 1 to 25 persons to help assure that the EU Act was actually being implemented, might not be enough, right? So that's a concern there as well. And there's also, of course, the limited risk applications, deep fakes, emotion recognition, AI interacting with humans, and minimal risks where there's only residual harms, at least under the model of the Act, with voluntary codes of conduct. And I think that the place where Jean-Claudio and I are heading with this is the sense that essentially in these areas, I think at least with several of the applications, even in high risk and limited risk, there should be some role for regulators to get a look at the data collection, the proposed data collection, proposed analysis, and the proposed uses before they go into effect, rather than trying to chase after them afterwards. And I think there's two major values to that. One is transparency, right? Because I think a lot of us are at present being judged or modeled in ways that we have no idea about. We just don't know what's going on. And I think that, to the extent that at least you have a third-party regulator knowing about that and needing to license it, even if it were a relatively straightforward and easy licensure process, at least you have some public record of that, or some record of it, kind of like the patent system. And the second is that it would allow for stopping, before they even start, some of the most troubling applications of AI, particularly in AI that is judging and evaluating individuals. So that's where I would sort of think about, in terms of thinking about future regulatory models. I know that this might seem a little bit utopian, given the lack of resources even allocated with respect to some of the well-established GDPR principles. But I think it's worth having, at least in the back of one's mind, and starting, for example, with the most high-risk applications that use the most data by the largest firms. So even if it seemed like, well, how could you license everything? This is a growing field, et cetera. One could start with these very large online platforms, say, as I think they're classified in the Digital Services Act or Digital Markets Act. And one could start with certain very high-risk activities, say, for example, modeling health conditions or suicidality. That's something that's become relatively common, as Mason Marx's work has noted. And for firms that are very large, using large amounts of data. So that would be my initial cut at the problem, where I think that the idea of licensing everything is certainly utopian. But finding points at which we want to move to an ex ante model as opposed to an ex post, I think should definitely be on the agenda in these areas. Thanks.
Yeah, I mean, I think there is a lot of truth in sort of the shift towards stronger, ex ante controls and checks, and I think that would go a long way in terms of creating that trust and avoiding to put a lot of the burden on either the individual having to check what is but at the same time on enforcement, because the reality is that it's the control before the product gets into the market that is important. And as you say, I mean, it may be utopian to say that we can, license every single thing. My only concern always around this is also in the Act is that the fear that we take these AI systems as something in isolation, right? So, and not something that is compounded with other systems. And therefore, by saying that something is high risk, then, yes, it could be, but it could be, but if it's put together with something else, it could become high risk if it's not in the first place. Or, once you put it out, it can become high risk in ways that you hadn't foreseen before. So I always have a little bit of concerns around this, but I mean, do you have any thoughts about this or?
That's a great point. I think that this idea of having of the possibility of, say, interacting systems, each of which don't seem terribly influential at one level, interacting. And I think that's where actually if one were to try to construe or to redraft provisions about the social score, to sort of look at sort of scoring over time or that happens in iterative or amplifying ways. An example that always gets given in these algorithmic accountability discussions, for example, is say a credit score that at first is used just to determine what credit someone gets. But then, at least in the US, we see car insurance and home insurance being based on the credit score. And then all of a sudden, like something where we might feel comfortable with the score having a certain level of impact given the level of process or of input that a person has to influence it. We may say, well, that's just about credit, so we're not going to worry too much. But when it comes to the point where they can't even insure their own belongings or they can't insure their house, and then it turns out that home ownership depends on the insurance, and then it turns out there's all these other things, and then perhaps even job opportunities or other things may depend on where one could live. All of those things, I think, are really interesting in terms of thinking about amplifying, interacting AI systems. And that's another situation where, yeah, the question of the validity of data going into certain of these systems and thinking about how data goes into one AI and comes out as an output, and then that output is used in data in other AIs. That is, I think, not adequately on the agenda. I think you're absolutely right to highlight that. Yeah.
Thank you so much. And I'm going to bring in Cornelia Kutterer now, who's Senior Director, EU Government Affairs and AI Privacy and Digital Policies at Microsoft. And I wanted to ask, first of all, what do you think about these discussions around high banning or banning and but also high risk and all of that, but also in general, I just wanted to, if you could give us an overview of how you've reacted to the AI Act. What you think is missing? What is and where is Microsoft heading in this discussion?
Yes, thanks, Ivana, for those questions. Maybe I start at a high level in Microsoft's approach to responsible AI, and our own internal advances are quite significant and quite impressive, really, when you look at how we were able to scale the rolling out of our internal standard. That standard is built upon our own ethical principles. I shall say they're really aligned with other national, international ethical principles. But what we have been doing over the last 3 years is really asking the hard question in how do you actually operationalize these principles and how do you overcome the socio-technical challenges in doing so. So our standards now look at describing for our engineering groups specific objectives that they shall meet in order to achieve accountability, transparency, inclusion, etc. In this context, we've done quite a bit also internally on facial recognition. As you might know or not, in 2018, Microsoft called for the regulation of facial recognition technology. We have published our own 6 facial recognition principles that guide our internal work and our work with our customers in that space, that are based on fairness, transparency, accountability, non-discrimination, notice and consent, and lawful surveillance. And I think when we look at specifically the AI Act, I think the ban in public spaces is a result of the risks to potential surveillance. And I'll come back to that point a little bit later. We have also, and I think this is a really important aspect, both for how to improve eventually the AI Act, but also more general to think what GDPR regulates. I'm really intrigued and looking forward to hear more about Theodore's study that really looks in particular at the application of data protection laws in that space. But in reality, it's a lot also the specific use and how this use is actually executed that will be important in order to mitigate certain risks. So we have, for example, published transparency notes that really help our customers to inform them about the responsible deployment, provide guidance on the image quality, for example, or how, for example, environmental factors might impact the result of the use of facial recognition technology. When I talk about this, I mean really broadly the use of both those that are potentially in the exemption of the AI Act, but also that are in Annex 3 listed in Annex 3 for the high risk applications. In this context, I will say that we, in the way Microsoft deploys our standard, we're doing this across our AI system. So engineering groups that develop AI system will have to comply with our internal standard. And that allows us, and this is eventually a significant difference to the AI Act, because it allows us indeed to look through during the development at potential risks. And in the development, we will then potentially mitigate those risks. And the risks and where we have heightened scrutiny, internal scrutiny, is when we consider certain risks as sensitive use cases. These are largely aligned with those in the high risk Annex 3. Of course, we are more flexible, right? Because it's not as defined as it is in the list, and this can evolve. But the mitigation really starts at development and might have impact in how we contractually deal with our customers in the deployment side as well. So it's eventually, if I may say so, a more holistic approach covering all types of potential risks. Needless to say that we have actually welcomed the focus of the Commission on high risk, because we thought it's really important to start somewhere and do it right. And I think that the challenge in how you actually regulate, as I sometimes say, the good intention is not so easy. So in Annex 3, for example, we don't have really defined what risks the Commission actually were thinking about. Is it discrimination? Is it equity? It's probably all of that. And then how do you actually work towards this is described in very technical manners on the provider side, but not on the deployment side. And there are certain factors that are missing. Just when you think about, the quality of the use of facial recognition technology by law enforcement might be impacted by the cameras they are using, or by the ability and the knowledge of the people that are involved in using them. So all these aspects also play a role. Now, on the assessment of the proposal itself, and a couple of things maybe first. First, there has been enormous advances in facial recognition technology compared to a couple of years ago, where we saw a lot of the unfortunate use cases that populate still today the public discussion. So the technology has advanced, and the understanding and how to create data, also training data, in order to mitigate certain differences in quality of service based on ethnic groups is also considerably improved. So just those things. Now, when we have looked at the EU proposal, we look at it in the context of the legal framework in which this proposal is developed. And very differently from the situation in the United States, Europe has obviously the Human Rights Convention, a human rights framework that is able and has been since the 60s to actually address new technology. So the Malone case, for those who are studying this, have seen that you can develop, and this is sort of the case where the proportionality, necessity, and safeguards parameters have been developed, and I think they apply here too. And when you think about applying those, the Commission's proposal, seen under this lens, has tried to find that balance between maybe where they landed is they landed on the fact that the use of the facial recognition technology in law enforcement in publicly available spaces does not infringe the core of the right to privacy in the public. When this is your starting point, then you have to think about, so what is it necessary and is it proportionate, and what are the specific safeguards? And this is sort of where the list of the exemptions come. What we have now done in this context according to our own principles and our beliefs in this space. We've looked at how the Commission has built those exemptions and have thought, okay, there is improvement in building out the safeguards and potentially even the proportionality. And based on discussions we had over the years also with the Fundamental Rights Agency, where we had a workshop over 2 days, and where a lot was discussed about the watch list, who is actually on the watch list against which the identification is happening. So we thought, okay, we can look at which crimes, which situations would potentially merit the use of those technologies. You have the CCTV cameras, and then you have a watch list against which you run the facial recognition technology. That's one space. Where we also felt improvement needs to be done is really in the public transparency. So law enforcement needs to be more transparent about when they are using it. So having annual reports, allowing the public to have the scrutiny is also something that could eventually improve the proposal that Commissioner has put forward. Again, there are a couple of others, and then there's a lot of technical details that eventually should be thought about, that you can eventually evolve through standards. Remember, when we have passport pictures, the EU has also standards and the quality of those pictures. So we know about how to build these standards out to improve some quality. So there are a couple of elements that are missing in order to make the safeguards robust enough for the use in the spaces. We also, and that's a debate, I'm not sure whether we should even talk about this, but we really felt you can sort of shorten or make it more succinct for what type of crimes or situation it could be necessary.
Pernilla, thank you. I'm going to now ask for the sort of consumer perspective of all this. And I'm asking Ursula Packer, who's the Deputy Director at the VUC, the European Consumer Organization. So I'm very keen to understand sort of your perspective on this topic, and whether, what is missing in order to sort of provide sort of the safeguards that the consumers need, sort of from a sort of consumer's perspective. How do you think we should move forward?
Yes, thank you very much, Ivana, and I'm very happy to be here, and thank you very much for the organizers, for inviting also the consumer perspective. And I'd like to discuss a little bit the prohibitions or the practices that are listed, but maybe first I'd like to give you a little bit of a flavor of how we approach the proposal for the AI Act from a consumer perspective. And there, maybe let me just say, from a very superficial reading already, you see a few symptoms, if I can call it like that, that then if you dig deeper, have led us conclude that this is not a proposal that really comes with a high level of consumer protection, as it should in the European Union, where there is an obligation actually on the institutions to do legislation and policies with a high level of protection for consumers. So maybe just to list a few of these symptoms. First of all, there is a definition of a user in the proposal, but that is a user that is only an institutional or a business user. It's not the end user, it's not the consumer, so that is not real an element that is of importance in the proposal. Then the protection of people, the protection of citizens, of consumers is not a legislative objective in the proposal, which is also very unfortunate, because as the European Union life cycle of legislation works now under better regulation, evaluation of law, if it's still fit for purpose, also of course looks at the legislative objective of a proposal. So it's important that these things are expressly mentioned, and this is not the case, unfortunately. Then, and I come back to that, we don't have economic harm protected in the list of prohibited practices. It's only about physical and psychological harm that is listed there. So that is a major lacuna. And then, of course, last not least, it's a horizontal framework, but there is no horizontal rights given to consumers, and that is particularly pertinent when it comes to remedies. There are no remedies for consumers if something goes wrong, and the whole dimension of private enforcement, so enforcement by private entities, be it a right to a complaint or a right of a representative action for collective redress, is just not provided at all, so basically ignored in the proposal. So these are just a few elements. And then, unfortunately, I haven't been able to listen to the discussion. I understand from the chat it was a very interesting panel just before us, but I've seen the Commission, Mrs. Sioli, intervene in the first session, and I heard again what the Commission seems to say, that the AI Act needs to be understood as building on European legislation that already exists. And so we are speaking about, of course, the GDPR, we are speaking about product safety legislation, we are speaking, of course, of consumer law. But at the same time, the European Commission and the European Union says we want to put forward a global standard. But I have to say that even for a person like me, who I think is reasonably well equipped in terms of understanding safety legislation, consumer law, data protection law, it's extremely difficult to understand the whole structure and architecture and how it interlinks with other European Union law and what the real impact would be of this piece of legislation. So what I'm saying is that I don't see how this piece of law can serve as a global standard, because you always have to know a little bit more about what would the GDPR do and what would the GDPR prohibit in order to understand what is really possible. So I think from terms of legal certainty, but also in terms of consumer protection, so not only legal certainty for businesses, I really talk here with a private use perspective, so not so much about institutional users or public authorities. Legal uncertainty is not provided, I think, for businesses, but it's also not good for consumers, because if consumers are not clear about their rights, it kind of translates into no rights for consumers. So this is a very important point. So making it short, there is a lot to improve. I've been happy that Mr. Benifei from the European Parliament said that they are fully aware of that, and they're up to the challenge to really improve the piece of legislation in front of them. But indeed, there is a lot that needs to be done. I'd like to focus on a few points. So first of all, on the prohibited practices, we are very much in favor of having a list of prohibited practices, of course. But again, when it comes to private companies that use AI, that is really problematic. We think that the proposals that the Commission made in Article 5 do not go far enough. I come back to that in a sec. Then the scope is a problem. We are also in favor of a high risk oriented approach. But here we have a very special combination. We have a very broad material scope, because the AI definition is very broad. But on the other hand, the concrete requirements are only very narrow for a few high risk uses. And so we have these two groups. One is product safety related legislation and what is under licensing, as you would call it, system, and the other one is the self-standing users under this Annex 3, which the Commission says is a use case approach, which I think is problematic, because I think Frank already gave examples where why is credit scoring a high risk and insurance scoring not? I mean, it doesn't make sense, and we would have really, I think, problems to update also these lists. The mechanism Commission has provided is really not good enough. And I'd really be interested also to discuss, why do we need this use case approach, and why can we not combine it, for example, with a regulatory approach similar in the GDPR, where we have a few very important high level principles like fairness, transparency, etc., and that applies to every data processing, personal data processing. So why can we not have that also for AI? I think that would be a much better approach. And it's not maybe always about licensing, which is pre-market approval, but it's just that there are some legal standards that apply by default, and that you don't need to go back to sector-specific legislation. And then maybe just to come back, but very briefly, because I think we're running really out of time, and maybe I reduce it to the biometric data and the prohibition there, because again, now talking about uses of, for example, facial recognition by private entities, and we think there is an increased trend to normalize biometric data and biometric identification practices, which is problematic from a privacy and from a security perspective. I think what, if I may say, Professor Christakis Theodori has explained is that the GDPR is definitely not enough. This Article 9 has a huge uncertainty in terms of there is a big discretion for the member states to regulate. There is a big leeway for different interpretations at the national level, but also on a case-by-case basis. And so the GDPR is definitely not enough. What we are asking for is that for remote biometric identification system, it's not only for public uses, law enforcement, but there should also be for remote users a ban on private entities to use such techniques. And I'd be happy to make also comments on social scoring, for example, is certainly a very problematic practice, as also I think Frank has said. But it is not explicitly regulated under the proposal if it is used by private entities. We know that, for example, Airbnb holds a patent to score the trustworthiness of consumers. So you may not have access to certain products or services if you are ranked like that. And that is not really regulated at all. The Commission may say this is maybe something under consumer protection law that is regulated, but I can only say, and I know consumer law, this is just at a very high horizontal level. Cornelia is laughing because I think she has a history in consumer law too. But it's certainly not enough to provide the protection. Emotion recognition, same thing. Very problematic, but the use is only regulated in terms of giving more transparency. And we know that transparency in a data economy is not enough. I stop it here because we're really running out of time. Sorry. Thank you.
Thank you. I mean, this it's really, I mean, it's really good to really good perspective in here. And ultimately, I mean, I know we've got about 15 minutes left, and I'm taking 5 more minutes. But I just wanted to ask you a few questions to follow up on all this and bring it together the questions that are in the chat. So ultimately, I mean, I just want to take a step back, which is, I mean, regulating regulating AI is a rather complex area, and ultimately you're not regulating AI, but you're regulating the behavior of people surrounding the deployment, development, and the behaviors around it. And to me, there are two different elements in here, and I'd like to then one is how sort of the EU AI Act is certainly not the general law of AI. And I don't think that's the point that Lucilla was making earlier today. You know, the idea that there are, as Ursula just reminded us, you know, there are other intersecting regulation with all the limits that they have. And that's the first point. And then there is an issue around whether the intersecting legislation, whether the existing legislation in consumer law, human rights legislation, privacy, they are updated enough to cater for the requirements coming from sort of new technologies. So there is an issue which is before all this, which is, you know, it is the remit of the EU AI Act, which is in sort of in how we define it. And I think this is something that we are debating a lot, and so debating a lot in terms of how far should we go. I mean, Brando Benifei was saying earlier very clearly, was saying, well, we need to make sure that we have mechanisms of redress for individuals, but is it the space of the AI Act to regulate that? So these are all open questions, I think, that we need to consider. And I think these are the key points in my view. You know, so, you know, we can all debate the European AI Act, but I think the main issue is trying to understand what is the European AI Act actually there to cover. Is that enough, or do we need to change sort of the way that we approach it? And I think, you know, this is we can debate the nuances, but I think the bottom line is really around this. It's really around what are we here to regulate? What is the European Union here to regulate? Theodore, I just wanted a little bit of your opinion on this, because I mean, I know your focus is very much on FRT, has been in the discussions, but I really wanted to hear your thoughts about all this, about the points that Ursula was making.
Yeah, thank you very much, Ivana. I think it's a very important point that you raise. And once again, I will use the example of facial recognition. Do we need to update? I think that there were two parts in your question. Do we need to update current legislation? And I think yes. For instance, if you take Article 10 of the Law Enforcement Directive,
exactly.
It's very interesting because in some countries, for instance, this requires not only strict necessity, but also a specific authorization of processing of biometric data in member state law. And then you have some cases, when we're talking about biometric data, this could be fingerprints. You know that we use fingerprints, that there are laws that are, there is a legal basis to use fingerprints in criminal investigations for more than a century now in some countries. So can you use, for instance, a decree dating back to the 30s, which authorizes the use of fingerprints in order to do facial recognition? Some states say that this is enough, that in the context of individual identification for criminal investigations. Other countries say, no, it's not enough. We really need a specific legal base. Even though we have a legal basis about fingerprints, we need a specific additional legal basis about facial recognition. So, for instance, a law authorizing biometric processing fingerprints will not become a Trojan horse for facial recognition. These are the kind of issues that are extremely important, because when Article 10 of the law requires an authorization by union or member state law, it's not just about a sentence authorizing this. It's about introducing all the safeguards, all the protocols behind, all the necessary things that we need to do in order to address the risk of facial recognition. So we need to adapt. Now, your second part of the question, is the AI Act enough to do this in this specific example? If we take, for instance, the proposals of the Commission concerning the use by law enforcement, and with the caveat that I said before, and there is a question in the chat, and I agree that this is very controversial and not convincing, the distinction between real time and post. This is not really, it might be one of the criteria in some cases, but not a major criterion. But if you take the whole logic of the Commission, which is, to impose very strong pre-market requirements so that the software use will not be biased, etc., this is a very important part. And then the second part, that you will need a specific authorization or a specific law, only in some cases with authorization to do some things. This makes sense. Now, I don't want to say that this is necessarily the best option, probably banning some things and entirely, or the debate is open. But I was just thinking that in such a case, for instance, using the AI Act could be enough in order to update existing law. You don't have to go back and for instance, and amend the law. You can do it through the NI Act, adopt a posteriori law, could remedy to some of the deficiencies of previous legal acts.
Thank you. Frank, there are a couple of questions for you in here, conscious of time. There is one here asking if you think, from Mayor, asking if the prohibition of social scoring is enough when scores from private public system feeds into each other and possibly having the same effect, which sort of there was something that also was saying. And also, how do you see AI policies will evolve in cyberspace, considering Facebook's metaverse?
Great. These were terrific questions. And I noticed also one about sort of something like carbon permits. And yes. I do have to apologize. I've got to run right at 11 a.m. for a meeting. But I will say that, like, essentially, just to very quickly answer them, the question by Merv Hickok about the question about the citizen score and the issue of the prohibition with respect to, like, this sort of feeding in of certain data from private sources, I think is incredibly important. And I think that the data from private sources needs to be subject to whatever standards would be given to challenge to data from public sources. Data from private sources would be subject to the same levels of challenge that we would permit for public sources, and vice versa. But there's got to be a harmonization there, because the sort of divide between public and private is often a very thin and ever-shifting line. I think also the question about AI policies with respect to sort of something like a carbon permit, I think that's very interesting, because I've been thinking a lot about where does the state try to influence the algorithms and the AI themselves, and where does the state say, look, you do what you want, but if you don't certify with us, you can't use it in these different contexts, right? And that question about trying to change the optimization function or to change in other ways to try to influence what's actually going on in the analysis of data is a really interesting one, and one that I think will be showing up with search engines, social networks, other areas where we try to regulate. And then finally, the last point, well, that might have been all the point. Oh no, the carbon, yeah, that was the carbon permit point. And the last point was the metaverse point. That I'm afraid I'll have to pass because I think it may take a very long time for that to actually materialize. But thank you.
Cornelia, there's a question here. I wonder whether what your thoughts are on this. It says, could panelists imagine putting the regulatory line on the intended outcome rather than the technology? For example, ban on tools in schools, effective AI designed to influence in children's character and their human development, rather than focus on faulty design like discriminatory bias.
I think it's a great question, and it goes to a point where we have been struggling within the AI Act, which is the enormous focus of the provider's intended use versus also looking at how the deployer it actually is using it. So in other words, we need accountability, not only accountability and transparency in particular, and efforts to be inclusive and reach fairness in the system, both by the deployer, but also by the provider, but also by the user / deployer. And that goes a little bit, it's maybe a different way to argue the case that Ursula is making, but the point that she's raising for consumer issues is the lack of remedies. I think if you don't even understand that a specific deployer is deploying the system, like for example, a public authority or any retailer that sells stuff to consumers, then you wouldn't actually know. So I think the transparency, accountability, in order to provide consumers, I will say consumers, citizens, or customers, depending on the circumstances, the information they require to actually get more information to see whether a specific decision impacts them in a certain way. So it's really, I think, a gap here. And the gap comes from, it really, many of the issues that have been raised come from the fact that the Commission has used the new legal framework, so product safety legislation, as the basis for the overall approach. And in Annex 3 in particular, I think that is a challenge because we are looking at socio-technical issues that manifested themselves in the development of the AI system, but also in the deployment of the AI system. So, and that in particular in the deployment, you want to focus on the outcomes. You want to focus on the objectives, like for example, instead of having error-free data, which doesn't really say anything about the objective, what you really want, you want to have an outcome where different groups, ethnicity groups, for example, have the same quality of service so that you don't have discrimination. So we actually need to reformulate the technical requirements, much more focused on the outcomes that we want to achieve. I would agree with the question.
Thank you, Cornelia. Ursula, I just wanted to ask you, there's a question in here from Govind saying, I wonder if the context of consumer rights and remedies is something similar to the treatment of medical pharma innovations, if something like that could be applied here.
Thank you for the question. I'm not really 100% sure what it implies. If it's about licensing maybe of pharmaceuticals and having a specific
and the checks and
agency
controls before release,
I guess that's it. I mean, I think to a certain degree that's what the Commission has done with this new legal framework approach with safety and conformity assessment that has to be assessed and evaluated by accreditation bodies, etc., etc. I think the problem we have here is indeed that the Commission has taken a 20-year-old regulatory concept, which is this new legal framework, which was introduced into the European Union, also for our international audience maybe, to make sure that products can travel cross borders in the single market. So it was an accreditation system to say this is CE marked and this is conform, and now you can use it and go across borders and no national legislation can stop you. And this is very much linked to technical standardization. I know that you talked in the previous panel, unfortunately I didn't hear it. But now if we take this, and this is what I think it's a regulatory choice, I'm not sure it's the best choice the Commission made, and now you impose it, so to speak, on new technology and practices that have huge impacts on societies, on fundamental rights, on consumer rights, and we end up with standardization bodies having to figure out what would be the technically right way to implement fundamental rights requirements, if we had them. Again, and there is not enough at all specified in the legal basis, which is the AI Act. So I think it is something that is highly problematic. So I don't think that we can just take the pharmaceutical approach and say this is the blue kind of print that we can need, but I think we would really go away more from this conformity assessment and this rather outdated approach that Commission has chosen as a fundamental element, unfortunately.
Thank you. So thank you. Conscious of the time, 4 minutes past 5 in Central Europe. So you can imagine that we've run a bit too long. I'm very grateful to you all. I mean, these are very complex discussions. I mean, it's not easy to regulate in this area. And there are so many different things to consider, and in particular, I think it's really important that we have and we host this discussion. So I'm really grateful to the Future Privacy Forum for giving us the opportunity to be talking about all this. So I'm going to hand over to you, Gabriela.
Thank you so much, Ivana, and thank you to our distinguished speakers. We are incredibly grateful for having your time, for having your expertise. This has been an absolutely wonderful symposium. I want to thank all the attendees that stayed with us throughout the last 2 hours and a half. It wasn't a really small feat, but I think we had conversations that were very relevant, and I think everyone leaves the symposium a bit richer in understanding AI regulation and the different approaches around the world that we are seeing. On behalf of the organizers from the Future of Privacy Forum and from the Brussels Privacy Hub, thank you to all, and we're waiting all of you next year for the Brussels Privacy Symposium. We promise it's going to be just as good. Goodbye, everyone.
Couple of drinks.